The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this morning in the matter of 4 separate cases. The first 2 will be held by oral argument. The second 2 will be submitted without oral argument. The first hearing is Planned Parenthood of the Heartland versus Kim Reynolds and others. Second case is State Line Cooperative versus Iowa Property Assessment Appeal Board and Emmett County Board of Review. The third case, which does not have oral argument, is Rick Riley versus State of Iowa and Iowa Department of Transportation. And the final case without oral argument is State of Iowa versus William Fettner. We'll begin with the Planned Parenthood case. Counsel for that case today are both participating remotely. So I'd like to do a quick sound check. And we also have Justice Apple, who's participating remotely. The other members of the court are here on the bench. And it's my understanding, and I'm hopeful that if the court wants to ask a question, I thought if we wave our hands just a little bit, it makes it easier for the people on the screen to see that we want to talk. So we'll try to do that today, since we have more people on Zoom than usual. All right, we'll start with this for the state. I believe it's Thomas Ogden. Are you there?
Yes, Your Honor.
Justice Apple, can you hear Mr. Ogden?
I can. Thank you, Counsel.
And Mr. Ogden, can you hear Justice Apple?
Yes, Your Honor.
Thank you. And how about Planned Parenthood? I believe we have Rita Bettis-Austin.
Yes, Your Honor. I am. Yes, Your Honor.
Thank you. And also, I believe Julie Murray. Is that correct?
Yes, Your Honor.
Okay, thank you. We will start with Thomas Ogden on behalf of the state whenever you're ready.
Thank you, Your Honor. Before I begin, I'd like to thank the court for accommodating us remotely on such short notice. I think I can speak for Julie and Rita when we express our gratitude for the court's efforts and flexibility under these sometimes challenging circumstances. With that, I will begin. May it please the court, this case is about the state choosing with whom it contracts to deliver its message about sex education and teen pregnancy prevention. As multiple federal circuit courts have held, the state is not required to enlist abortion providers to deliver that message. This case concerns 2 grant programs, the CAP and PrEP programs, that are designed to provide comprehensive sex education to Iowa teens. In 2019, the Iowa legislature amended the eligibility requirements for the CAP and PrEP programs to exclude entities that perform abortions, entities that promote abortions, and entities that affiliate with any entity that performs or promotes abortions broadly. Because Planned Parenthood fits all 3 of these, it must show that all 3 are unconstitutional in order to maintain eligibility as a potential grantee. The district court concluded that the challenged law violates the Equal Protection Clause of the Iowa Constitution and granted summary judgment in favor of Planned Parenthood. So I'd like to begin by addressing the equal protection argument. The Equal Protection Clause of the Iowa Constitution, as this court explained in Varnum, is essentially a direction that all persons similarly situated should be treated alike. As a result, whether Planned Parenthood is similarly situated to other eligible grantees for purposes of the law is a threshold question. Now, while the curricula for the CAP and PrEP programs do not include discussion of abortion, they do cover topics such as abstinence, sexual activity, contraception, sexually transmitted infections, and teen pregnancy. As perhaps the most well-known abortion provider and advocate for access to abortion in the country, it's the state's position that a contract with Planned Parenthood to provide CAP and PrEP programming could create a perception that Iowa at least implicitly approves of Planned Parenthood's performance of and advocacy for abortion.
But I take it there's nothing in the record to suggest that in the past Planned Parenthood has overstepped the statutory restrictions.
That's correct, Your Honor. we do not have anything in the record to suggest that Planned Parenthood has improperly included discussion of abortions as part of the CAP and PrEP programming.
So for purposes of the statute, and the statute, I take it the purpose is sex education. Maybe that's too blunt, but that seems to be the purpose. For purposes of the statute, then, Planned Parenthood is similarly situated to any other applicant. They're capable of complying with the statute and that the state has required.
Justice Apple, your question cut out just a little bit. You said that it was, for purposes of the sex education statute, that it was similarly situated, and I think you were saying more.
Well, they're similarly situated because the purpose of the statute is education pursuant to established criteria, and Planned Parenthood and other potential grantees are similarly situated in terms of their ability to deliver on the grant.
Respectfully, Your Honor, I would disagree. I think that the risk that the state is concerned about is a perception that goes beyond the actual performance of the programming under the grant. I think that, if you're a parent or, a citizen of the state and you find out that Planned Parenthood is providing sex education under these programs for Iowa teens, I think that there's a risk that you would react to that differently than you would react to somebody who is not engaged in extracurricular, for lack of a better phrase, performance of abortion or advocacy in favor of access to abortion. And I think that distinguishes Planned Parenthood from grantees who do not engage in those activities outside the scope of the program.
Counsel, then how do you respond to the carve-out that's included in the statute?
The carve-out applies to distinct locations of nonprofit healthcare delivery systems, and at least as you can tell from the record in this case, it applies to a organization in Muscatine that's an affiliate of the Unity Point Hospital system. And the state recognizes that, while hospitals may perform some small number of, I assume, medically indicated abortions, they're not really in the same category of organizations that Planned Parenthood is. You wouldn't, in general, associate a nonprofit healthcare delivery system like Unity Point Hospital with performance of an advocacy for abortions. So I think that while the district court treated the exception in the statute fairly broadly, I actually think it's on the narrow side and really makes sense when you consider that addressing the concerns that I've identified, the legislature would be careful not to paint with too broad of a brush and maybe excise someone from the program who doesn't really pose the same concerns that an organization like Planned Parenthood does.
Mr. Ogden, this is Justice McDonald. As a factual matter, is Planned Parenthood the only organization that's excluded from receiving these funds and then delivering the curriculum?
Well, I believe that the technical answer to that question is no, although I think I get what you're getting at, which is on this record, Planned Parenthood is the only, I believe, grantee that has received grants in the past or applied for grants while this litigation was ongoing that became excluded as a result of it. Although the statute certainly would include other potential grantees, as the record shows, Planned Parenthood
would it be permissible for the statute to specifically identify PPH and exclude them from participation in the program versus the general language that's used in the statute?
I think that it would, as long as there was a rational basis for doing so. But that's, of course, not the situation that we have here. As far as the statute is concerned, I understand that it did, that was the circumstances that the programs, the applications were faced with at the time, but the statute certainly doesn't target Planned Parenthood by name, and it doesn't, from a technical standpoint, apply solely to them. So I want to, even if Planned Parenthood were similarly situated to other potential grantees who do not engage in any of these activities, the exclusion of abortion providers, it's our position that still is constitutional under the equal protection challenge because it satisfies the very deferential rational basis test. Planned Parenthood is not a member of a suspect class, and the exclusion of abortion providers does not affect a fundamental right because it's the state's position that Planned Parenthood does not possess an independent right to perform abortions.
Counsel, this is Justice Oxley. Do we need to decide that issue to decide this case, whether or not providers have a fundamental right to provide abortions?
Well, I think that in order to determine the proper level of scrutiny for the equal protection challenge, I do think that issue comes up because under the equal protection framework, if Planned Parenthood is similarly situated, well, you don't have to decide that question if you agree that Planned Parenthood is not similarly situated, because that's a threshold question. But if you conclude that they are, then the rational basis test applies unless the plaintiff is a member of a suspect class or the legislation affects a fundamental right. But because the law in question doesn't condition participation in the programs on a woman's foregoing her ability to choose to terminate a pregnancy or to obtain an abortion, and because, as the record is quite clear, the legislation will have no effect whatsoever on access to abortion, it's the state's position that it does not affect the fundamental right and the rational basis test should apply. The state presented the district court with 3 plausible policy justifications for excluding abortion providers from these programs. First, as courts have recognized all across the country, the state is allowed to express a preference for childbirth over abortion. And in the CAP prep context, that means that the state could rationally conclude that contracting with Planned Parenthood to deliver sex education and teen pregnancy programming sends the message that it approves of abortion as a method of family planning when it does not. It also might have concluded that some parents would not accept Planned Parenthood as a sex educator and would therefore not permit their children to participate in CAP prep programming when they otherwise would.
Counsel, on that point, you mentioned other cases across the country. A lot of the other cases involve restrictions on use of the funds within the program, and so speaking within the program, as opposed to this legislation that focuses on the grantee. And so I think that brings up the issue that Rust addresses. So can you address the difference between this legislation focused on the grantee as opposed to the program itself?
Sure. The state's position on that question is that what we're talking about here is essentially a program that involves government speech. And there's a couple of principles that have been made clear from the cases. Obviously, the Rust line of cases suggests that the government is not allowed to regulate speech outside the scope of the program. And the Rosenberger and others have suggested that when the government is sending its own message, it's allowed to choose the speaker. And I think that what we believe the synthesis between the two is that there is an exception to the Rust paradigm for a situation where the selection of a speaker whose speech activities outside the scope of the program would threaten to undermine or confuse the government's message within its program. And that was discussed in the Fifth Circuit case, the Sue's case. And we believe it was also, at least implicitly accepted in the first open society decision. And we think that that's the situation that you have here. While, as a general matter, it's not acceptable for the state to regulate the speech of a grantee outside the scope of the program, we think that it is allowed to do so where the selection of the speaker based on their speech outside the scope of the program would threaten to undermine or confuse the government's message. Another plausible...
Let me jump in here, sorry. I believe that one of the two programs has actually already been, PPH has been a recipient for maybe 12 years, is that correct? The CAP program?
I believe that's correct.
And PrEP for about 7 years. So that argument you just made regarding that the childbirth preferred over abortion, during that 12-year period, for example, and you know the record better than I do, is there any evidence or data to show that that actually became true? That when you allowed PPH to give this message of sex education, that there was a confusion or misguiding the message of the state?
Not on this record, no. But, the legislature, when you're talking about the rational basis test, you're talking about conceivable bases on which the legislature could have acted. And, any different legislative session is allowed to change its mind or to change directions. And so while I would agree with you that this record is devoid of any evidence of that kind of confusion in the past, I don't think that under the rational basis test that prevents them from acting in the future. And finally, the district court could have, or the legislature could have concluded that it did not want to indirectly subsidize the efforts of abortion providers like Planned Parenthood by contributing to an increased presence for these organizations in Iowa communities and among Iowa teens. I'm sure that I'll have other comments in rebuttal argument, but I'll leave it at that for now.
Thank you, Mr. Ogden. And it's my understanding Ms. Murray will be arguing on behalf of PPH?
That's correct, Your Honor. So I'd like to pick up actually with a question from Justice Oxley about the carve out for Trinity Muscatine with respect to the equal protection analysis. And I think that that carve out is only one piece of evidence that this law is irrational, but I think it is certainly a very strong piece of evidence in that respect. The exception for Unity Point that the Iowa legislature created here renders House File 766 extremely over and under inclusive. And to give an example of that, I would just point out that Unity Point's Trinity Muscatine location could refer for abortion, it could advocate for abortion rights, it could affiliate with abortion providers as it does as being part of the Unity Point system. And it could still obtain grants under the CAP and PrEP program so long as it operates from a facility that doesn't provide abortions, even though these are community-based services anyway, so they're not going to occur in a clinical setting. Meanwhile, Planned Parenthood of the Heartland could stop providing and referring for all abortions in the entire state of Iowa. It could stop advocating for abortions here tomorrow, and it still would not qualify for the exemption under the statute because it provides abortions.
Ms. Murray?
Yes.
You know, what we've said in the past under the rational basis test is the fit doesn't have to be perfect. It can't be extremely over-inclusive or extremely under-inclusive. But here, what the legislature has done is essentially deny funding to the entity that provides 95% of the abortions in Iowa. That doesn't strike me as extremely under-inclusive or extremely over-inclusive, does it?
Well, 2 points to that, Your Honor. As to the extreme over and under-inclusiveness, yes, we would agree that that is the legal standard, but we think that it is not appropriate in assessing extreme over and under-inclusion to only look at the set of circumstances before you. And that's supported, for example, by the Ward v. Rock case that we cited in our response brief. The second thing that I would say to that is, even if you set aside the exception for unity point, the law still does not further any valid, realistically conceivable purpose. And I think that's clear from the statute structure and from the legislative record here that this law was intended to do one thing: to target Planned Parenthood of the Heartland with precision. And even under rational basis review, that kind of invidious discrimination simply cannot be logical. And I think that's borne out by the results here. So by applying this law, if it were to take effect, it will not have it will not serve the end goal of reducing teen pregnancy. Instead, it will leave Iowan youth in 5 of 6 counties where Planned Parenthood of the Heartland offers CAP and PrEP services with no other provider of these critical services for youth. Far from reducing teen pregnancy, House File 766 will in fact make it more likely that teens will go without services and have unintended pregnancies.
And I'd like to kind of follow up that statement with how the state ended its argument. According to the briefs, the grant you're talking about, that it has such critical services for those 5 counties, doesn't that only represent 1% of your annual revenue? Isn't that a program you could easily just cover?
No, Your Honor. I believe, and I would have to look back at where this is in the record, but I believe that the amount of funding is actually approximately 20% of the Iowa education budget for Planned Parenthood of the Heartland. So it is not an amount of money that would just be replaced. And I would say as well, go ahead.
I'm sorry, I didn't mean to say only the education budget. I'm probably talking about the entire budget. And don't you decide how much money of your entire budget you put into education?
Well, that is certainly driven by funding considerations throughout the organization. I will say, though, that the CAP and PrEP dollars contractually cannot be used to supplant other activities of the organization. So it is not the case that these activities would continue in the absence of CAP and PrEP funding. In fact, the funding...
But Counsel, I mean, isn't it true that money is fungible and that funds that Planned Parenthood might otherwise use for education, it can use the state's funds for that and transfer these funds or transfer other funds for uses that the state disagrees with?
2 responses to that, Your Honor. No, in this case, the CAP and PrEP funding is not fungible. And I would point, Your Honor, to the record, the stipulated statement of facts at paragraph 32 to 34, where the respondents indicate that they have never argued that Planned Parenthood has used these funds in furtherance of providing abortions. As I said, that is also borne out by the contractual obligations that Planned Parenthood of the Heartland has consistently followed for years. And I would also direct, Your Honor, to the Alliance for Open Society Institute case, where this very argument was made with respect to the funding condition in that case. And the Supreme Court said, you cannot simply assume that the funding that comes from a government program will be used to supplant funding for activities of which the government disapproves. If that were true, then you could always impose a constitutional condition on people's exercise of constitutional rights where funding is at issue. And that exact argument was, I think, very persuasively rejected by a majority of the US Supreme Court in that case, in part because, one, you can't sort of assume that as a baseline matter. And there, as here, there is not a shred of evidence that that is, in fact, what has happened with CAP and PrEP funding.
Counsel, this is Justice McDonald. I wanted to follow up on a statement you made that the purpose of the law is to target PPH. And when I asked Mr. Ogden about that, I think his indication was the statute could specifically identify PPH and that the targeting was permissible. And I assume that's on the basis that the government, as speaker or at least funder of the speech, has a legitimate interest in selecting with whom it contracts and with whom it provides funds. Could you respond directly to that the targeting is permissible and constitutional?
Sure. Our position is it would not be constitutionally permissible to target Planned Parenthood of the Heartland by name, and that this law, in effect, does the same thing. I believe we stated in our response brief, there was a legislator who said, we're not targeting them by name, we're just using what they do as the indicia for exclusion from the program. So we believe that that would be impermissible. I would like to point out—
Why wouldn't it be a legitimate reason for the government to pick and choose with whom it contracts or provides funds in and of itself? And if it decides that it doesn't want to contract with a particular organization, then it shouldn't have to.
Well, Your Honor, I think that that goes to the unconstitutional conditions doctrine, that even it is definitely true that the government can decide what kind of speech it wants to fund. And it has done so here by selecting the curriculum that are used in CAP and PrEP programs that Planned Parenthood of the Heartland provides. That's in paragraphs 25 to 27 of the stipulated statement of fact. It has decided the speech and the message that it wants to convey through this programming, and Planned Parenthood of the Heartland is equipped and, in fact, for years has provided that message. So in that situation where the funding condition, as Mr. Ogden candidly concedes, goes outside of the programming, the state here is not arguing that Planned Parenthood of the Heartland is not able to provide the expected state message through this program that is—
Ms. Murray, let me follow up on that. If indeed we're talking about government speech, and it seems like you're conceding that point, can't the government in effect pick the agency that it wants to deliver that speech? I mean, if Iowa wants to promote ethanol, can't they choose to contract with an ad agency that doesn't do work for oil companies?
Well, Your Honor, two points to that. I think that with respect to your hypothetical, I can tell you the analysis that would apply to that. First, you would ask, could the government directly say, you set aside the funding, you cannot contract with an oil company? I don't know the answer to that under Iowa law, but I think the analysis that's appropriate is, could the government do this directly? In this case, the government could not tell Planned Parenthood, you cannot provide abortion, you cannot speak in favor of abortion rights. And so the next step in the unconstitutional conditions analysis, if the government couldn't impose the condition directly, is to ask, is the condition part of is it defining the program or is it defining the recipient? So I think that in Your Honor's question, you would apply that analysis just as you would apply it here. But here, the rights at issue are fundamental: the right to abortion, the right to speech, the right to association.
Justice Waterman here. Can we rely on the unconstitutional condition doctrine without first establishing that Planned Parenthood has a right to provide abortions? And I'm not aware of any case that has so held. Can you tell us one?
Sure. So in direct response to Your Honor's question, there are cases that have so held. The Planned Parenthood Association of Utah v. Herbert case in the 10th Circuit is one of them. I believe in our response brief, or actually in the record, we cited in our response brief some other district court cases that have held to the same effect. I would say, Your Honor,
has the U.S. Supreme Court held to that effect? And aren't there decisions like the Sixth Circuit and Hodges that hold directly to the contrary?
You are correct that Hodges held to the contrary. The Supreme Court has not held that. What I would say to that, Your Honor, is that this court does not need to establish that a provider has an independent right to provide abortion, because the state here has conceded that patients under the Iowa Constitution have a fundamental substantive due process right to obtain an abortion. And under the unconstitutional conditions doctrine, the target of the condition is not required to accede to the condition in order to have a claim. So, for example, in the retaliation—
But counsel, I mean, if Planned Parenthood doesn't like the condition that goes along with these funds, isn't there recourse simply to reject those funds?
No, Your Honor. And this, again, I think the Alliance for Open Society Institute case persuasively rejects that argument. That may be the condition if Planned Parenthood, for example, didn't want to provide the message in CAP and PrEP programming that promotes abstinent, sexual education. In fact, that is consistent with its mission, which, we provide a lot of contraceptive services and other educational services. But here, Planned Parenthood is able to provide that message. And when the government restriction goes outside the contours of the program, even if Planned Parenthood isn't entitled to this money as a baseline, once the government establishes the grant program, it cannot condition the exercise of constitutional rights outside of the program.
Let me give you another hypothetical related to that. So let's assume the government wanted to fund anti-racist curriculum for teenagers. And as a provision in the statute, it excludes any organization that engages in racist speech. That might be protected speech as well. Tell me why that's not a legitimate interest for the government to exclude that speaker from delivering that curriculum if they agree to deliver it as set forth in the statute.
Well, Your Honor, I don't trust my imagination to come up with all the bases on which that could be potentially held unconstitutional. But I will tell you this. I think what you are describing, your hypothetical, is a situation in which the message to which the government is objecting outside of the program is directly antithetical to the message that the government wants to fund in the program. That is not the case here, where the government has conceded, and this is again in the stipulation of facts at paragraphs 25 to 27, that these programs do not have an abortion-related message. They are designed to prevent teens from getting pregnant in the first place. And I'll give you an example that I think is actually more...
I agree with your distinction, but isn't the larger principle, though, the government does have some right to select the speaker, and what you're arguing about is really whether or not the selection here was valid or whether it's logical, and not whether they have the right to make that decision.
I would agree the government has the right to decide what it wishes to fund. I will say the more likely analogy, or the context in which this is more likely to come up, is imagine Iowa said, we don't want to allow CAP and PrEP programming to go to abortions that have an anti-abortion message, to organizations that have an anti-abortion message, and that would be equally unconstitutional. If there are no further questions, we would urge this court to affirm the district court's decision.
Thank you. Mr. Ogden, response?
Thank you, Your Honor. I want to start by addressing the issue of over and under inclusion as it relates to the exception for Trinity Muscatine. I think that the critical point there, and what you can see in the hypotheticals that Julie laid out and that are also found in the district court opinion, is that the basis for concluding that exception makes this legislation extremely over or under inclusive do not do not apply to the exclusion of abortion providers. They apply to the exclusion of entities that promote abortion or that affiliate with entities that promote or provide abortions. And the court does not need to reach the constitutionality of either of those two exclusions from the CAP and PrEP programs if it concludes that the exclusion of abortion providers is constitutional, because Planned Parenthood can't get relief if even if those others, I'll call them the sort of First Amendment parts of this, even if those are unconstitutional, Planned Parenthood is still excluded as a grantee under the exclusion of abortion providers. And so therefore, the court does not need to reach those issues. As I believe it was Justice McDonald pointed out, or maybe Justice Mansfield, the exclusion or the exception for Trinity Muscatine is certainly not irrationally over or under inclusive as to the exclusion of abortion providers, because Trinity Muscatine doesn't provide abortions and couldn't provide abortions and maintain eligibility as a grantee here. The district court didn't really address that in its opinion, and we think that under the rational basis test, at least for the exclusion of abortion providers, gets us across that line and is frankly all the farther that this court needs to go under the doctrine of constitutional avoidance.
Mr. Ogden, let's assume that we thought there was an issue with over exclusion and under exclusion. Could we sever the carve-out as a potential remedy for that issue?
That's a good question. I think that I don't think that you could sever the carve out. I think that you're certainly allowed to interpret a statute that could otherwise be interpreted in an unconstitutional manner in a constitutional one if it saves it. And obviously the severability doctrine permits the court to sever unconstitutional provisions while leaving constitutional provisions intact. I hesitate to nail myself down on this, but I think that my instinct is that particular portion, I think it would go too far in taking over the role of the legislature to kick that part out.
Does Section 101 of the bill allow us to do that? It has an explicit severability provision.
It's possible that you could rely on that section to do that. But I don't think that that's necessary in this case, because I don't think that exception makes this the exclusion of abortion providers or either of the other sections, frankly, but certainly the exclusion of abortion providers. It certainly doesn't rise to the extreme degree of over and under inclusion that would cause a statute to fail under the rational basis test. You have to keep in mind that and I believe it's the Racy opinion that talks about this, but the idea of over and under inclusion is not one that originally applied at all in the context of the rational basis test. That was only a concept that was used when you're looking at something using heightened scrutiny. And I think it was Racy where this court said that that could come to bear in a rational basis context if the over or under inclusion was so extreme as to render the justification wholly irrational. And we think that that's certainly not the case here, where you have 95% of all abortions provided by Planned Parenthood.
What about the argument that Ms. Murray makes that in evaluating under-inclusiveness and over-inclusiveness, you need to look at the statutory provision and ask, is that statutory provision under-inclusive or over-inclusive? So here you have this Part 2 of Section 100 that has a carve-out, and the carve-out by itself, one could argue, is arbitrary without getting to questions of over-inclusiveness or under-inclusiveness. That you need to look at each provision.
I see my time has expired. If I may briefly respond to the Justice's question.
Please do.
Yes, I think that even looking at the exclusion on its own, it is not arbitrary. It is, in fact, makes a lot of sense when you consider the intent or the goal of the exclusion of abortion providers from this program, because the concerns that the state has identified do not apply to somebody like Trinity Muscatine, who doesn't provide abortions, is not associated with the performance or promotion of abortions, and could otherwise be excluded from these grant programs basically on a technical reading of the preceding parts of the statute. For that reason, we would ask the court to reverse the district court and
Thank you. The case of Planned Parenthood versus Kim Reynolds et al. Is hereby submitted, and we will have just a pause in the proceeding to allow an opportunity for the next attorneys to get prepared for State Line versus Iowa Property and Emmett County.